and welcome to another episode of War on Words. Today, we're going to be talking about third world approaches to international law, and we have with us Frédéric Mégret. He is a full Professor and Dawson Scholar and co-director of the Center for Human Rights and Legal Pluralism at McGill University. Thank you so much for being here with us today.
Thank you for having me.
So I've been following your work for quite some time, but I wanted to start off by talking about your piece in Opinion Juris, which I read with a lot of interest because it's a conversation, which articles in Opinion Juris hardly ever are, between an expert on the law of armed conflict and a concerned member of the public about civilian killing in Gaza. And it really highlighted for me the many issues with the law and war lawyers and how we explain the laws of war to members of the public, and complex questions of weighing military advantage and civilian life and suffering, and the fact that many people argue that you can't even make that calculation at all. And there's a very interesting bit in the piece where the person is saying, what about what I can see with my own eyes, which is dead children and dead civilian life? So I wanted to ask you whether you believe, as Tolstoy does, that making war more humane, insofar as that's possible at all, merely makes it more acceptable rather than leading to its abolition, which is what the ICRC hoped would happen.
Sure. I don't know if that's what the ICRC hoped would happen. I mean, certainly there's a complex relationship between humanizing war, reforming it, and the goal of abolishing it. In the 20th century, certainly in a Western tradition, you can see the two diverging, right? And being at odds with each other. And on the humanitarian side of the equation, the idea has very much been to claim a very separate realm of regulation and to insist that the jus in bello, the regulation of war, should be entirely detached from questions of abolition. And, the laws of war only work as a project based on the recognition that war is inevitable, and, our best hope really is to try to humanize them at the margin. Now, whether that project succeeds or fails, I think humanitarian lawyers are probably the first to say, the laws of war are frequently violated. I think the project's saving grace is that, sometimes it does protect some people, and that's better than nothing. So it depends what your comparison is, right? If your comparison is genocide, then a kind of heavily regulated warfare seems far preferable, right? So compared to wanton violence, the laws of war are an improvement. Compared to no war at all, the laws of war are a huge concession to violence. But, I think historically, if you look at the second half of the 20th century, so what's really interesting is war is abolished, right? At least supposedly, right? And certainly only interstate war is what we're talking about, right? And so there, the position of the International Committee of the Red Cross becomes much more awkward, because why would you continue to regulate something that is illegal? And how will you not be accused at some point through that kind of ongoing overinvestment in regulation of undermining the prohibition on some level? And, I think the Red Cross is fairly sort of clear about this. Say, well, we're pragmatists. We don't, wars will happen whether we want it or not. And one reason why they're right, of course, is that even the post-Second World War regime anticipates a system of jus contra bellum where there's, even if there is a war, there's going to be someone acting as self-defense who's acting entirely legally. So there's no, we fight war with war in the international system. If you think of Ukraine right now, no one is waiting for the international police to arrive, right? We fight fire with fire. And so war is deeply woven into the international legal system because it's one of the means of enforcement.
Yeah, and I think that the way the international system tries to get away from that escalation in terms of the prohibition on the use of force, but then when there's an armed attack, you're allowed to use force in self-defense. It doesn't work when you have countries trying to expand that notion under Article 51 to suit their whims all the time. And I think it's very interesting from the perspective of the global South to look at what Russia is doing in Ukraine, because whenever we hear these Atlantists talking about the rules-based international order, the global South is just looking at them like, what about Iraq? And what about Israel? Two countries which frequently, you broke it in Iraq and you allow Israel to break it very frequently, and you never talk about the rules-based international order there. So I feel like their hypocrisy is very overt when it comes to Ukraine, and I think that's why the narrative isn't really working in the global South, but also in terms of what international law is used for as a tool, it is quite interesting to see.
Yeah, no, I think that's right. So, there's certainly an element of double standards involved. I think, it's not Ukrainians' fault at the end of the day. They are the victims of an all-out assault on their country. But I think it's true that some Western states come to that conversation with already a record of violating the prohibitions on the jus ad bellum themselves. And, I don't just mean, and I'm particularly thinking of, the superpower of the US and although there are others, but in terms of flagrancy, we're talking about the invasion of Iraq. We're also talking about, the war on terror as a sort of broad amorphous paradigm that has allowed the unleashing of violence in countless spots in the world. And so I think, other countries, public opinions look at this and, the jury is out. In some ways, I think it's actually tragic if it lands us in a place where attacking other states becomes acceptable because, others have done so in the past. So there's a lot of work to, I think, shore up that prohibition, but also rediscover why it was important and meaningful. I am ambivalent about the kind of global reaction to the Ukraine. I mean, I understand that it's frustrating when the West is sort of asking everyone to coalesce in that case because it suits their geopolitical agenda, but not in other circumstances. I'm also reminded, though, that with norms of international law as important and central as the prohibition of aggression, we're all in this together. So if a norm becomes weakened, if this, weakens us too. And, I think of places like the Congo, which, has been the theater of, several wars in the last 15 years. And we're talking about interstate wars, not non-international armed conflict that went all the way to the International Court of Justice to sue Uganda, obtained, a victory there. But, that norm is important to the global South, has always been. And it really is, I think, a taboo. So that you really shouldn't be invading other countries. So the question is, how do we uphold that norm in circumstances where we have reasons to think that some major players are sometimes or often acting in bad faith? I should say, though, that it is quite complex, right? So the US doesn't have a monopoly on illegal uses of force. I mean, I think of Rwanda, in Congo, or there are lots of states tempted by military adventures in other states. The only difference is, of course, the US has the means of its ambitions, right? So it has the ability to deploy force extremely far from its territory.
Yeah, and I think perhaps the most disappointing thing is the rise of the doctrine of unable and unwilling. and taking out non-state actors in other states' territory through that, and the use of that by the global south. So we had that used by Turkey. We've had that also used in some way by India against Pakistan, and now Pakistan has also gone into Afghanistan to take out the TTP there. And so the only doctrine that kind of justifies any of these uses of force in self-defense is unable and unwilling. So if you have our states also taking upon this undermining of the international rules-based order in this way, it doesn't help things. I did want to talk to you a little bit about drone strikes and your arguments about the otherization in the international law, and about how the unlawful combatants category in and of itself kind of harks back to this savage versus civilizing mission of international law, and how it's largely US and Israeli arguments that there is this third category beyond you being a POW or protected person. You're an unlawful combatant, and we can do with you as we will want to, because the laws of war don't apply to you. So in Pakistan, we've seen this otherization in the form of drone strikes. So even the liberal hero Obama actually upped the amount of drone strikes in Pakistan, and you were guilty until you were proven innocent. And so the criteria for being selected to be targeted by a drone strike were kept incredibly secret. And there were rumors coming out that actually just going on top of a hill to try and find a cell phone signal, that could be signaling a strike. And you were, so long as you were a military-aged male, they assumed you were a combatant unless it was proven posthumously that you weren't a combatant. So will we ever be able to decolonize these laws, is my very broad question at the end of all of that.
Sure. Well, I don't know. I think maybe starting with that general question, it's very hard to decolonize anything that is thoroughly colonial in its history. I do see, though, that there's always a kind of ambiguity. Norms exist, but they're also used in certain ways, right? And so I think the laws of war historically have certainly had a decolonial orientation to them. Think of Protocol 1 and struggles of national liberation, etc. So I mean, nothing is played in advance. The problem is indeed who decides and how are the laws used. And there is an underlying subtext, right, that's inherited from an earlier era, and that is prompt to be resurrected in certain circumstances. So here, clearly, with the concept of unlawful combatants. So I think, with unlawful combatants, it's a complex issue. So I think in the laws of war, one can accept there is such a thing as an unlawful combatant, as a third category. So, the Americans were quite clear during the Second World War, ex parte Quirin, these German saboteurs, dropped off New Jersey somewhere. They're not wearing German soldier uniforms. They're using violence, but without, displaying weapons openly or anything, and they're tried for that. They're not given prisoner of war status, and I think that was probably the correct call in the circumstances. I think the problem is when that category of unlawful combatant becomes extended to an entire people or an entire type of non-state actor, when it is overlaid with kind of racializing tropes, when it is bereft of any procedural guarantees, etc. So, and there's a part of me that thinks, well, probably that's a category that should exist in principle, because we want people who use violence, and that comes with certain privileges, to self-identify themselves and, not be perfidious, etc. At the same time, you potentially open a whole sort of can of worms with this, especially, I'd have to say, and this has been the problem since struggles of national liberation, in conditions of radical military and technological asymmetry, where it's extremely easy for one side to be wearing, I mean, the Americans in many of these cases might as well be wearing sort of, red and gold, ceremonial uniforms. They're operating in offices thousands of miles away from the scene.
Yeah.
And so, there's no cost for them to be identifiable. But when you are talking about sort of guerrilla warfare in difficult terrain, etc., and sort of non-state groups that are very relatively disorganized, at least, then it's very more harder to identify yourself. It's also harder to even be able to wage war. So I think at least, in decolonial struggles, the colonizer was there. If you were the FLN in Algeria, the French troops were there. You could shoot at them. But I think increasingly, we have warfare being conducted completely remotely on one end, at absolutely almost no risk to life, because drones are being used, and so these groups, in a sense, cannot fight back, and that we have to sort of appreciate what that means, right? And how untempting it makes the idea of a fair fight. Why would you want to have a fair fight with someone you cannot possibly access, right? And so here, maybe what we're seeing is the end of war, right? And we're not seeing it in Ukraine, but we're seeing the end of war in other places. And I would add one element to this, which you mentioned, but I think is very important, is just the rise of violent groups and non-state actors. This is not entirely new, of course, but there has always been a question about how you regulate asymmetrical conflicts, right? Even outside the colonial, post-colonial context, what do you do with groups that are not supposed to be using violence in the first place, because they're not public actors, they're not states, etc.? How do you create some kind of buy-in for them in the laws of war, right? Given the asymmetries built into the laws of war, right? And the fact that your combat, unless you're part of a national liberation movement, but it's not privileged, you're, at best headed to prison. So the question is, what's in it for you, right? Why should you do it? Is it out of humanity, sentiment of humanity? But if so, where does it come from culturally? How do you, I think one of the big problems of the laws of war is that, as international law in general, still very much steeped in a universalist mindset. So the idea is, what will motivate people is that their state at some point signed a piece of paper in Geneva, and so everyone will kind of fall in line, and if they don't, will punish them for failing to comply. And that doesn't really account for why people respect norms. I mean, people respect norms because they conform to their own cultural code of behavior, right? And so, we need to work on that, I think.
So many interesting points there. So whenever I'm teaching students about unlawful combatants, I always tell them there are like 3 levels of protection. So either you become a POW and everything is fine and dandy, apart from it isn't, but either you become a POW, or if you're not, if you don't fulfill Article 4, then you become a protected person under Article 4 of GC4. And then if you fulfill the nationality requirements in that you share the nationality, then you're only protected by Article 75 AP1, or you're protected by the allegiance concept in Tadic, which was brought to the fore there. So I feel like the argument that there is a third category kind of changed with the ICTY's jurisprudence, in the sense that actually you become a POW if you're not that, you become a protected person, and then if you're not that, you become just protected under Article 75. And that's why it's so frustrating because so many students ask me, what about Guantanamo? What about the fact that there are so many Pakistanis there who are getting released after like 20 odd years. And even when we're looking at it in the sense of asymmetric conflict, I really love the quote you had in the first article, actually, I read of yours, which was the Thucydides quote, that of all manifestations of power, restraint impresses men the most, because when we see these people playing on their joysticks in Virginia and then shooting and dropping bombs on people so many thousands of miles away, the asymmetry of power is also inherent in the weapons that they use, because the weapons that they increasingly use, they sound horrific, like the Hellfire 2 weapon, which has just all of these blades in it so it can slash the victim, which means that it doesn't explode. So proportionality, it can comply with that more, because you're not going to kill people within the blast radius, you're just killing with these like ninja swords the target of your attack. And so I think that actually leads to a very innovative creation of like a proliferation of drones and a desire to do that more, and to be the entire time to say, oh, well, we're complying with the laws of war with this. And also the fact that they don't win. So like even in Vietnam, even in Afghanistan, with guerrilla warfare, and even with these so much more high-tech weaponry than we saw that the Taliban had, it didn't compare to having on-the-ground intel. And so the desire to take your own civilian casualties out of the mix entirely, it doesn't seem to pay off that well.
Yeah, no, I think that's true, and I think these asymmetries are endemic. I think one of the long-term decisions in the West has been to remove bodies from the battlefield, right? To replace with technology. And that's a sort of deeper move, right? I mean, Chat GPT will soon be writing our articles for us, etc. And there has always been a bit of in sort of Western modernity also a fetishism of technology and innovation and things, right? Procedures, rules also in the law, but also just military gadgets, right? And these are very ambiguous. On one level, they do allow more precision, and to some extent get that. I mean, I think, people are still, being sarcastic about smart bombs as if it's 1999 and Kosovo, right? I think, actually smart bombs are getting smarter. I mean, it's a reality. But there's also a kind of liberating element to that technology and a kind of inebriation, right? Linked to its use, that you can do all these things. So why wouldn't you, right? If it's as easy as pressing a button. And then that gets us into really interesting calculations that I think are insufficiently discussed in international humanitarian law about the relative weight you assign to, let's say, your own combatants as opposed to enemy civilians, right? So how much risk should your own troops be taking in an effort to minimize casualties on the other side? Now, that is almost never discussed. I mean, even if you think Protocol 1 and sort of collateral harm and the military advantage, I suppose you can fold survival of your own troops into military advantage. It's kind of there somewhere. But this is really some of the trade-offs that are involved. And if you hyper-value the lives of your own combatants, and I think this is the trend that a lot of militaries are in, then you proportionally devalue the lives of civilians on the other side, right? And that's not the way it was supposed to work. The way it was supposed to work is, that civilian lives, because they're innocent, means that people who are not involved in an armed conflict, just have really important to what international humanitarian law does. So, these calculations are being made all the time. They're very difficult to second guess. International criminal tribunals have been very bad at prosecuting sort of collateral harm. The argument always seems to be, well, we're already too busy with direct targeting of civilians. Why should we? We can't really be bothered with these sort of complex, questions of conduct of hostilities. Yet, I think, seen from outside, it's difficult not to get the impression after a while that this eventually tends to favor the powerful over the weak, right?
Yeah.
And
especially when you have some countries taking like 3,000 judge advocate generals with them into war. There's a reason that they do that, and it's to get a sign off in terms of the Israelis and especially the Americans of operationalizing these war lawyers and being like, okay, no, we took the strike and it was definitely a legitimate one. Especially Israel does that so much in Gaza when it comes to the precautionary principle. So they will ignore distinction, proportionality, focus on precautionary principle and be like, we told everyone to get out. And you're like, you're bombing an open air prison, which is Gaza. So I'm not sure that you can really abide by the laws of war there.
Yeah. That's right, and can I thought the comment on bringing lawyers with you, which is one that David Kennedy made, I think, very compellingly a few years ago, is a strong one. I mean, it says something about the complicity of lawyers in violence. It says something also about the ability of law to launder violence and make it seem completely legal. It shows that there is always an argument, there is always a way, and that the law, in the end, sort of facilitates violence, perhaps because the law is itself a form of violence, right? It's the ability to kind of process violence through its categories and legitimize it. And the one thing I wanted to say on that is that a few years ago, some American legal scholars came up with the idea of lawfare. And lawfare was kind of, in the spirit of some at least, was something that kind of the Palestinians did by, and by sort of putting, let's say Hamas military targets next to schools and hospitals. And I mean, the underlying sense was, well, this is really a bit shocking. They're abusing the laws of war, etc. And I would say that the original artisans of lawfare are, the Americans and the Israelis, the ones who are extremely invested in the laws of war, and really committed. I've maybe to complying with the laws of war, but it all depends what you mean by compliance, right? I mean, the laws of war allow you to tolerate a huge amount of violence. And if you play your cards right, they will sort of fundamentally help you. And I think that's what a lot of armies discovered is, on balance, it's not just that there's a certain legitimacy to not be seen as targeting civilians directly. It's that the laws of war provide you with a discipline of fire, which is very much consonant with war aims.
Yeah, and I think so. We work on lawfare a lot here, and I always have so many issues with the term, especially when I found out it was coined by Charles Dunlap. And every time I've read one of his articles, I've been like, no, I don't want anything to do with lawfare. It's interesting to deal with this in the sense of what I do here, because I originally came to Pakistan to work in human rights law, and I was so disenchanted with human rights law. And I don't know if you read Samuel Moyn's books on really taking down human rights law, but I was reading them and I was just like, this is exactly how it is. And I think that when I look at it in the sense of how Pakistan has been played in the human rights field, like especially in terms of the EU is now saying that if you want to have access to trade tariffs, you have to ratify the Rome Statute. And Pakistan is, very reluctant, which you can understand, to ratify the Rome Statute and potentially see its servicemen in the docket at The Hague. And I think that I just kind of wonder about the human rights movement, especially in terms of conflict. Like it is great in that we have another forum to redress grievances, but they're very heavily individualized and they're very heavily Western-centric, human rights, these are the ones that matter. Your right to, complain about not having any food rather than, the right to have food. That's the more important one, which we're constantly told by the Western human rights model. And I just wanted to know what you think of that as someone who also works in both fields.
Yeah, so look, are human rights helpful? Are they not helpful? It really boils down to what you mean by human rights. And so, I remember Balakrishna Rajagopal a few years ago wrote this piece on the international human rights movement where he made the argument, the human rights movement is often identified with leading Western luminaries and NGOs, but we could redefine the international human rights movement as the independence of Haiti, as desegregation, as decolonization, so as the anti-apartheid struggle, as solidarity with Palestine. So, these are just terms. I understand there's a certain dominance, right, within the human rights movement, but of notably Western ideas, but I think it is complicated, and I think what we need is a much more pluralistic understanding of human rights. But human rights will mean different things in different cultures. They may be useful sometimes, not so useful in others. It's very much pragmatist when it comes to these things, in a sense that I don't think there's a real ontology to human rights, right? So we're not we are not really committing ourselves necessarily to a single conception of the human as much as to a certain praxis of foregrounding, let's say, human interests against state interests, against, the powers that be, etc. So it's a very capacious framework, and it's been used quite widely by groups. I do see there's an impoverishment potentially in any language that purports, at least nominally, to be universal. But universalism and pluralism in practice, it coexists, right? So I think on one hand, you can say you can stick to the kind of classic idea of human rights, but there is something to our common humanness. And in the same breath say, yes, but we're also extremely different. And, our needs are so peculiar, and we just need to do a lot more work in sort of, culture and anthropology and political economy and etc. So, is there a sense that the dominant international human rights movement has remained quite superficial, quite Western? Yes, but, and recently at McGill, we had Obiora Okafor, who is Special Rapporteur for the Human Rights Council on the human right to solidarity. And, what he had to say was very different from what maybe the Special Rapporteur on freedom of expression might have to say, coming from different backgrounds. So it's a big tent. And sometimes I'm a little worried that, so one possibility for our students, for example, is to disengage, right? And so to say, well, like human rights, it's all, Western, etc. But it's only Western if you allow it to be, right? And so the problem is if you disengage, you leave that kind of terrain open to the people who think they own it, right? And I think that's a problem. On the ICC specifically, I think it's kind of the same thing, right? So let's say the ICC is the shiny new tool in the human rights toolbox. So, there are costs to staying out. So I don't particularly, I always thought the concerns with servicemen were overrated. So France and the US have had those for a long time. And I think, the odds, one thing we know about the ICC is it's unlikely to prosecute anyone for just, isolated war crimes. And it's really about genocide, crimes against humanity. So, I think, unless you think that that's what you're involved, obviously then as a state, you don't want to ratify the Rome Statute. But I think, states should have a bit of, sort of robust sort of, faith in what they do and their compliance with the law. And also being part of these institutions is how you steer them, right? And you ensure they work for you. And I'm also reminded that being a member of the ICC, think of Ukraine. So will Ukrainian soldiers occasionally commit war crimes? Of course, I'm sure they will, right?
Yeah.
But on the other hand, being at least giving jurisdiction to the ICC has proved an incredible sort of insurance policy, right? It protects their territory to an extent. It protects their own, and so there's something to be said for that. So again, there's no final word, right, on whether one should join the ICC. What is shocking is that the EU is, quite inelegantly making this a condition of trade overtures, and that is, good old-fashioned sort of legal imperialism. Of course, we're not talking about, it's more a carrot than a stick strategy. And so I think in terms of global South sovereignty, it's maybe a little less shocking, right? So that, this is not sanctions, right? Saying, well, if at the end of the day, I think states are allowed to sort of trade with who they want. And it's if there are no takers, there are no takers, right? I mean, this is still the hard game of international politics. Some would say, well, Europe is kind of shooting itself in the foot by doing this because it's forfeiting trade opportunities, which would be great for its economy, in the name of, what difference does it make if an extra state, joins the ICC? So it's not just, I think some of it is just old-fashioned European arrogance, and you're going to do this, and this is how you should behave. Of course, it's still an option for states to basically say no and not, think it's worth it and not join the court. One thing maybe that we need to talk about more is sovereignty. I mean, you talk a lot about human rights, humanitarian principles, etc. Sovereignty is not a fashionable term in international law since, the 1990s. A lot of Western international lawyers think, want sovereignty gone. They think it's already dead. Human rights lawyers in particular have done a particularly bad job of understanding what could possibly be beneficial for human rights. About sovereignty. I mean, sovereignty is just the shield of tyrants and, Pinochet, etc. But in truth, sovereignty has always had, David Kennedy talks about the dark side of a lot of things. I think there's also a rosy side, right, to sovereignty. So, everyone is always focusing on the dark sides of sovereignty. But I'm reminded that sovereignty, particularly in the global South, was conquered the hard way. But it embodies certain collective aspirations. And of course, sovereignty may then be occasionally, I mean, Saddam Hussein or Gaddafi are examples not particularly well managed domestically, but it's still the sovereignty and a self-determination of that people, right? And it's still their leader, and it's still the ability to chart a path that is distinctive, that is not aligned with the powers that be. And that strikes me ultimately as really one of the determinants, even of individual dignity, is to not be part of a people that is subjected, that is humiliated, that is dominated from outside. So really, I think we need to rediscover that. And it was one of the great lessons of the 60s and 70s, but independence is really crucial.
Yeah, I think that's a really good counter about the ICC and being a part of it to steer it. I think part of my reticence as well is the changing of the prosecutor, because I think that the last prosecutor was brilliant in terms of how she tried to bring these charges, but you've had an ironically British Pakistani prosecutor who has deprioritized American crimes in Afghanistan, and that just it doesn't quite sit right with us being then told you have to ratify the Rome Statute, and it's such a highly politicized court as well. When it comes to human rights, I also think that maybe we're falling. One of the examples I always give to my students is the fact that if you put everyone in a room, everyone would agree that you can't mutilate children. So most people would be like, yes, the mutilation of children is wrong. Let's prohibit that. Let's get that out of the, out of practice. But then when it comes down to whether some people think that circumcision of boys, of, young baby boys is mutilation, some people will think it is, and some people that will be part of their cultural practice. So I feel like the argument that there should be more cultural relativism in terms of human rights, I think it's one that has kind of been left to the wayside. And I think we saw so much of that coming out in the World Cup in Qatar. There were so many, so many arguments about, human rights in Qatar and how terrible they've been. And you got to the point where I think that you weren't really allowed to say many good things about Qatar and how they treated people when they came to the World Cup, purely because of this portrayal of them in the Western media as being anti-LGBTQ, anti-human rights, not giving people the right to have alcohol. So yeah, I kind of wonder whether you can pin all of that on these fundamental human dignity arguments when there should be a lot of relativism there.
Yeah, I mean, I think it's Qatar was in some ways unfortunate. It's very difficult, right? I mean, human rights is a simplifying discourse, and I think there are things that some societies do better than others, and they're prone to think that these things are the things that really matter and that the others don't matter. I mean, I think, in some ways, I'd rather have a health problem in Cuba than in the US, because I think I would get, better healthcare, or at least if I was poor, I would get a fairer access to healthcare. But that is largely inaudible, I think, in the West. So, look, I mean, I think the Qatar, whatever you want to call it, success or debacle, is, I think, an invitation to think also about what it means to criticize the other, right? So from what standpoint do we think that we can disparage, and particularly in conditions where, you are the guest of a particular, of a country, right? Which in some cultures means a lot, right? To not, spit in the soup, as it were. And so, that's something that's fascinated me recently. What might be just human rights criticism, right? So there's a whole tradition of thinking about the just war, right? It's very problematic, etc. But it's still an interesting tradition in terms of to think about all things. And I think, criticism, I mean, there's a whole interpersonal ethics, right? About who you can criticize, when, in what way, etc. It seems when it comes to human rights, the authority of human rights and their importance is such that sort of anything goes, right? You can, and of course, criticism tends to be quite one-sided. There's a flow of criticism from the west to the south, and it's very unidirectional. I mean, I was heartened by the fact that Chinese a few years ago started adopting an annual report on the US's human rights record, right? But that was a bit of a propaganda piece, but it had some good points in there as well, right? On systemic violence against African Americans, etc. So I think, this is a question. So the critique is to say something about yourself. It's to say something about the other, but it's to say something about yourself and the position you think you occupy in that constellation. And I think that's where we should be a lot more inward looking when we do criticize the human rights violations of others, and when we are insufficiently sensitive to how our own criticism exposes our blind spots, right? And I use the our very loosely here. But so one thing that, so one classic, for example, is that you hear from the West is that, many societies in global South treat their women horrendously, right? So this is, just very strong, was during colonial days, is today. There's always something, whether it's the hijab, whether it's female genital mutilation, etc. It's very focused, particularly on Islam, etc. And of course, the repartee to that is, have you ever looked the statistics of feminicide in Spain? What about a culture of the bodies of teenage girls in the West that is hypersexualized from the youngest age? What about and you could go on, right? But it's not as if these things are actually really complicated, right? And so this is not to say that it's we can't draw lines and we can't have conversations, but they are murky and
it's been used to justify so much military intervention as well. When you look at, every time I look at the New York Times and it's a piece about the Taliban in Afghanistan, it's always these burqa-clad women in these like dark and dingy rooms. And even our Nobel laureate Malala, I'm just like, the story of this brown woman being saved by white men from brown men, I think it just plays very well. So the whole concept of these Muslim women need saving from Muslim men and only we can do it, I think it's such a dangerous one.
Yeah, no, absolutely. And this is sadly an incredibly successful and effective trope. And it shows that you also have to be very careful who support you in this. I mean, it's very tempting for civil society groups, etc., to get the backing and financing by Western foundations, etc. You have to be very careful, right, that you don't end up sort of reinforcing a script that ultimately subjugates you, right? And so I think there's always that risk. And I was reminded of this in the context of Iran and the protests there, and earlier waves of protests where all of a sudden some leading Israeli politicians or sort of bloggers extolling their support for the cause of Iranian woman, and I'm like, of course, but I mean, why not? But you have to, everything comes from a certain place, and you have to be extremely wary of who is saying what at what point and with what agenda, right? And so I think an important rediscovery for the international human rights movement is there are a lot of people with agendas out there, and they're very savvy. And I certainly, as scholars, we tend to be a bit naive sometimes about these things. But we should also be, I think, feel a certain responsibility for how the ideas that we produce intellectually, ideas about rights, about the laws of war, etc., are then used in the world, right? I mean, these are our babies in a sense. We don't own them, but we're part of a commentariat. We're part of a ecosystem, that makes them thrive. So it says something also about our responsibilities that these ideas get out there and are then used in all kinds of ways. Some predictable.
Yeah, no, I completely agree with that. I completely agree with the murky agendas that most people have and how to figure them out. This is such an interesting discussion. I know that it's gone on for 20 minutes longer than I told you it would go on for. But thank you so much for taking out the time. And I'm sure everyone enjoyed the discussion as much as I did at home. So please tune in for future episodes.